Hello, everyone, and welcome to our second lecture in Chapter 12 in our unit on the judicial branch. In this lecture, we're going to take a look at how the judicial branch works to shape public policy, so the policy of the government. So let's get started. So, kind of setting the stage. So remember, the Supreme Court is a political and legal institution. Now, its main job is legal. That's why it's number one. So it's there to settle disputes and interpret the meaning of the laws, specifically the meaning of laws as they shape towards the Constitution. And then two, politically, they apply the law to specific disputes and then determine the national policy. So it's mostly political. It's supposed to be outside of the actual realm of the parties. It's just supposed to be, okay, here's national policy. This is how they're determining it for the country. All right, so we're going to take a look at some of the tools they use to help determine the laws and the policy that's going to actually go. So when they pass laws, those laws themselves or their decisions, that focuses on policy, so where the nation's going to go. And that goes for every branch of government, not just the Supreme Court. So for our federal court system, mainly the Supreme Court, this is what they do. They have three things that help them determine the policies. One is judicial review. If you guys don't remember what judicial review is, you haven't been paying attention. But remember, judicial review is the ability of the courts to look at the law and see or cases and see if they're constitutional or not. Number two is they interpret the meaning of the laws, not just in terms of the actual power of judicial review. And then three, they can overrule or reverse previous decisions either at every level, even the Supreme Court. So remember that. The Supreme Court can actually overrule or reverse previous decisions they've made. Remember back to the example that we always use is Brown versus the Board of Education overturned Plessy versus Ferguson. All right, so let's look at judicial review. So it's the power to examine laws and actions of local, state, and national governments. You can actually cancel laws and actions if they violate the Constitution. The federal court systems, particularly the Supreme Court, have the ability to do so. This power was first assumed in the case of Marbury versus Madison, and that's what you guys need to take away from that case, if it hasn't been stressed to you guys enough in previous units and lectures in this course and even in this unit. You have to know that Marbury versus Madison established judicial review. Now, if the court rules that a law is unconstitutional, it'll actually discourage passage of similar legislation. This has actually happened several times throughout our country's history, and that legislation can be, that's more of discouraging it at the legislative branch level as well. Now, this can actually have a direct impact. An example of this would be the Dred Scott decision. And the reason why this is you have to think about the time period when Dred Scott was being tried in the mid-1850s. There was a lot of political things going on, legislation going on in terms of passing whether or not states should be free or slave, and the idea of popular sovereignty and so forth, and you had all these compromises and so forth. Our nation was at a tipping point on this issue over slavery, and with the passage of Dred Scott, that actually discouraged legislation that was trying to free land up and make it free, and complicated the whole issue. So, that's why that case is such an important kind of domino to fall in why our country went to civil war. Okay. Now, review and civil rights. So the power of judicial review and civil rights. There's a couple links there to some cases, most notably on the Miranda versus Arizona there. It's just a student. He actually created his own, does a really good job. You guys can please feel free to watch him if you choose to gain a little bit of understanding on Miranda versus Arizona. But presidential policies can be reviewed as well. So if the president makes a decision, the Supreme Court can look at it and say, look, you can't do this, or that's okay. They can make sure that they're keeping them in line. It's part of the checks and balances. Now, judicial review is mostly exercised at state and local levels because that's where most everything starts, and that's the highest number of courts in terms of amount and number of cases. So generally, judicial review is being practiced there. Remember, when we talk about all this stuff, these powers still exist. It's not just in the Supreme Court or the federal courts. It's also in the local and state courts as well. Now, recently, when we talk about recently in the last 50, 60 years, judicial review has been used to influence states in desegregation, most notably in the 50s and 60s, and into the 70s a little bit, and in reapportionment as more gerrymandering cases and cases dealing with representation have come about. And reapportionment, remember, is the process of going by and reworking the districts based on the census, which is going to happen here since we're in 2020 and the census being taken. Now, some examples of these cases, most notably with the influence in desegregation in civil rights, we have Brown versus the Board of Education, which ended segregation, which is an overturning of Plessy versus Ferguson, as I mentioned earlier. And then you have Miranda versus Arizona. So this is the rights that you're allowed in changing police procedures and the reading of your rights when you're arrested. All right, so let's go further in review in terms of interpretation. Now, you have to understand that the general language of Congress, so how they act and how they rule in the laws they put forth, as well as the Constitution, lead things to be open to interpretation. And an example of that was the PGA Tour versus Martin. That's a case where Martin actually, because of a disability, wanted to be able to use a golf cart. And this is an example, if you actually go read the laws that were focused on that, you can actually interpret things several different ways, even if you support Martin or you supported the PGA Tour's decision in why this got to the Supreme Court. And remember, the Supreme Court is there to decide the meaning of Congress, the meaning of the president, and the federal government, and the Constitution. Now, if the Supreme Court decides to overturn decisions, their rulings can be like a stare decisis. They can let decisions stand. This is where they actually it's mostly them setting a precedent. It's giving a model for the court, the nation at the time, as well as moving forward. Now, generally, the average law is predictable, but is flexible for the changing times. And this is the beauty of our Constitution and the beauty of the courts as they change, because you can have new legal views that can come in and say, look, we agree with this. This court agreed with it in the past, but now things have changed, whether it's across the nation, whether it's across the court, whether it's across the world, whatever. And you can actually see legal views change from time to time. And this is where you can get overturned decisions. Again, like Plessy versus Ferguson being overturned, Brown versus the Board of Education, Olmstead cases, wiretaps, and so forth. There's a bunch there. All right, now there are some limits that are on our Supreme Court, in our court system, really, in terms of shaping policy. And you have to look at these 5. You have the types of issues that are looked at, the types of cases, the overall control of the agenda of the government. 4 is the lack of enforcement power. We'll talk about that here in a second. And then checks and balances themselves, so the separation of power and balances. So the types of issues can provide a limitation. And the real reason why is because our court system plays a minor role in a lot of outside things, particularly like foreign policy. And that's because most of their cases deal with civil liberties or economic issues in the federal government. So since they're trying really cases only in those realms, they don't really play a role in other areas like foreign policy. Now, the types of cases, they can only try cases that make a difference. They can't advise on opinions that really have no real change. So they really only can try and look at cases that are going to change the actual policy of the country, such as ending segregation or establishing abortion laws or, gay marriage or same-sex marriage, having that established. Those are big changes, across the entire country. Number 2, the plaintiff has to suffer some kind of real harm, whether it's physical or psychological in some way, so they can't look at things where there is real no harm. Now, again, that's a little bit flexible depending on what you're looking at. Number 3, it has to answer a substantial question. That kind of goes back what I mentioned in number 1. And then number 4, they can't answer political questions. The Supreme Court, even though they're appointed and supposed to generally are looked at to follow the president's policies that appoint them, they're not there to be political. They're not there to be Republican or Democrat. They're there to, focus on the substantial federal questions. And then the control over the agenda, they really don't have control over that as much because they only can look at the cases that are actually coming in front of them. And then 2, you have to look at what the president does and the rest of the executive branch as well as Congress. All right, the lack of enforcement power is a really interesting one, and it's because the Supreme Court can make a decision, and this goes for actually all courts, but they actually don't have enforcement power. All branches or all levels can choose not to enforce rulings. So like the president, if they don't like the ruling of a Supreme Court, they actually don't have to enforce it. Lower courts can ignore decisions too because they just make the decision and interpret it. They have to be willing for people to actually enforce it. I'll give you guys a couple of examples, one in real life and one in a movie that I guess actually technically was in real life because of the movie. But anyways, so for example, when same-sex marriage was made legal, there was a woman clerk in Kentucky who would not grant a same-sex couple a marriage license. Well, normally that would have been, it's against the law for her not to do that, but there was no enforcement. And for a while, that couple couldn't get their license, but eventually the local law enforcement and head of the town stepped in and said, look, you need to abide by this. It's a law. If they hadn't stepped in, that rule, that couple may not have gotten their marriage license. Another example that you guys may know if you've ever seen the movie Remember the Titans, and you know that's about desegregating schools in Alexandria, Virginia, and it's a football movie and all that kind of stuff. Well, that movie takes place in 1971. Brown versus the Board of Education was in 1954. So for 17 years, in the city of Alexandria, they still had segregated schools, and Alexandria is right across the river from Washington, D.C., and that's right across from where the Supreme Court is. So it can kind of tell you their lack of enforcement power. They need others to help them. And then lastly, we have checks and balances. The checks and balances that are put in our system, in our Constitution, to make sure that the legislative branch and executive branch are checking their powers and not overstepping and becoming too powerful. One branch isn't becoming too powerful means that there are some limitations on everybody, including the court. And a couple examples of those are the president is the one that appoints justices, and they're approved by the Senate. And then Congress can impeach justices. Matter of fact, we've had several that have been impeached in our history, not for a long time, but we've had several that can be impeached. And then also those two branches are there to monitor and protect the court's integrity as well by working with them and making sure that, things like their rulings are carried out and so forth. All right, guys, that's all I got for you. We got one last lecture. I'll see you in that one here in a little bit. Hope you learned a lot. Have a good one.